All right, thank you everyone for coming today. My name is Danielle Bailey. I'm the Executive Director of the Alaska Bar Association, and today we're going to be hearing our CLE, The Taproot, Perspectives on the Pipeline in Alaska Legal History. I want to give a big thank you to our co-sponsors of the event, the Alaska Bar Historians Committee, and I see some people here that are on our committee, so thank you for coming, and I saw a couple names online as well. Just a couple housekeeping reminders for those of you that are online. I'm going to ask you to please mute your microphone. We are monitoring the chat, and so Kara will be taking questions as they come up. Also, for those who are here in person, please remember you can grab your certificate of attendance, and we also have evaluations out at the edge of the tables down there. And then I'm going to help get this discussion underway. I want to introduce our speakers. I'll kind of work my way down the table. We always have to make sure at our historians committee we don't have too many lawyers, so I'm happy to introduce Phil Wright. Phil Wright is an associate professor of history and Arctic Northern Studies at the University of Alaska Fairbanks. He's an engineer, energy and environmental historian with a focus on infrastructure, mobility, and climate change. Dr. Wright has written widely on Alaskan petroleum development and electrification, including histories of nuclear power in Alaska, the electrification of the Alaska's rail belt, and the cultural history of the Trans-Alaskan pipeline system. He has testified before the U.S. House of Representatives on Alaskan resource development, and his historical analysis has been cited in the New York Times, the Atlantic, and the National Geographic. Professor Wright also wrote his doctoral dissertation on the environmental history of TAPS and is completing a book investigating the 50-year history of the pipeline system. To his left is Willie Igiagruk Hensley, and he's probably going to help me with that pronunciation a little bit. I think fitting for Willie Hensley, he actually supplied me with the shortest biography, and he did not brag nearly enough, so I'm going to brag a little bit more than he intended. Willie Hensley was an instrumental figure in the formation of the Alaska Native Claims Settlement Act of 1971, which restored 44 million acres of land to Alaska Natives. It's the largest such conveyance in the history of the United States. He's a graduate of George Washington University with a BA in political science and economics. He served in our Alaska legislature for 10 years and was the founder of the Nenana Regional Corporation. Moving to his left is Justice Warren Matthews. Justice Matthews grew up in California and earned his Bachelor of Arts from Stanford University and then went off to graduate from Harvard Law School. He came to Alaska in 1964, where he first worked as an attorney at the law firm of Burr, Boney, and Pease in Anchorage. And then in 1969, he founded the law firm of Matthews and Dunn, later Matthews, Dunn, and Bailey, of no relation, unfortunately. In 1977, he was appointed to the Alaska Supreme Court, where he twice served as Chief Justice during his 32 years on the bench. And even though he retired in 2009, we've been very lucky that he has continued to serve as Judge Pro Tem, and I believe every single level of the court. And then last, but certainly not least, is Jim Reeves. Jim Reeves is a lawyer in the private practice in Anchorage of counsel to the firms of Holmes, Weddell, and Barcott. He graduated from Dartmouth College in 1967, and then from University of Minnesota Law School in 1970, so I'm always happy to have an alma mater person here as well. After his judicial clerkship, he came to Juneau in the summer of '71 to begin his Alaska career in the Department of Law, and he's been in private practice since 1978 with a short break in the 2000s where he served as the Anchorage Municipal Attorney. So thank you all for coming today, and I look forward to hearing from you.
So when I was asked to do this, they asked me just to tell the story of the litigation of the Alaska pipeline in 20 minutes, which is my problem. But I do have a unique perspective because I was the attorney for the Cordova District Fisheries Union and its challenge to the construction of the pipeline. And when we filed suit, we were consolidated with a suit that had already been filed by environmental groups, also challenging the pipeline. And so what I propose to do here today is to talk about that litigation, talk about the objectives of each plaintiff's group, talk about the outcome and how the objectives were either achieved or frustrated. And my conclusion generally is that from the environmental plaintiffs' standpoint, why there was much that was contained in the outcome that could be called positive. From the standpoint of my clients, unfortunately, there was very little that could be called positive. But let's go to the next slide. Go back to the first slide then. The first slide is the discovery, and that is really the second well that was found in Prudhoe Bay. The first one was announced around the first of the year in 1968, but it wasn't really, it was promising, but no one would say that it was really a giant field. But by the time a second and confirmatory well was drilled, by the announcement in July was, this is something that's proven. This is the biggest oil field in North America. It has 10 billion barrels of recoverable oil or more, maybe. And the price of oil at that time was about $3, can you believe it? $3 per barrel. But even at that price, no one doubted but that the exploitation of the field would be economically profitable. Now we can go to the next slide. So this is, my next point is that the oil companies were fast-tracking the pipeline right after the discovery. And this is Wally Hickel. I mean, there's something likable about it, really. He says, I drove the tractor the first 6 or 7 miles myself. I got off and told Jim, don't shut this thing off until you get to Prudhoe Bay. And that was Wally, really, but he was responding to an ARCO request. ARCO wanted to quickly finish development of its part of the North Slope field, and it needed some heavy equipment up there. So Governor Hickel decided to build an ice road, and the ice road was really poorly conceived. They scraped off the tundra covering the permafrost, and they managed to get to Prudhoe Bay in the winter, and it was actually used for about a month by ARCO to pull up some equipment. But by the spring thaw, why the permafrost just melted, and what we had was a wet ditch. And meanwhile, the administrations changed, the national administration. So the Johnson administration with Secretary Udall left. The Nixon administration came in. President Nixon appointed Wally Hickel as Secretary of the Interior. And so Wally's successor as governor, Keith Miller, named the road. He was proud of it. And so without any apparent irony at all, he named it the Hickel Highway. And that's what it was called. As it turned out, why it became, because it was never used beyond the first winter and never usable beyond the first winter. It became a symbol of what can happen if, with construction in the Arctic, unless proper precautions are taken. But it was part of the fast track effort. And ARCO announced in September of 1968 that they would begin to build a pipeline, and the pipeline would extend to Tidewater in Alaska, and it would be completed by mid-1971. They continued on the fast-track path by, in 1969, ordering the pipe and applying for a right-of-way permit. The pipe was delivered in the fall of 1969 and placed in storage yards up and down the Richardson Highway, and there it remained for more than 5 years. Other fast-track occurrences were that Alyeska, I call it Alyeska, it had various names, but at that point it was probably the Trans-Alaska Pipeline System Consortium, but it became Alyeska, so I'll just call it Alyeska throughout for simplicity's sake. Alyeska began collecting waivers from native villages. Native villages that the pipeline was anticipated, whose land the pipeline was anticipated to cross. They got the waivers free, but with a promise that they would employ the native village members on various aspects of the construction project. And that brings us to the next slide. What you see here are sections of the Alaska Statehood Act. The discovery took place in 1968 in a very important and unique context. And the context was there was a land freeze. What the land freeze meant was that the Department of Interior would not approve state selections, and indeed would not, finally it came to the point where the Department of Interior would not even approve private dispositions or dispositions of the public domain to private applicants. And the reason for this is here in this exhibit. Section 6 of the Statehood Act called for the state to select about 104 million acres of public domain, and it imposed a deadline of 25 years in which to do this. But Section 4 provided that the state could have no right to lands, the title or right to which may be held by Alaska Natives. And it further said that all such lands would remain under the absolute jurisdiction of the federal government until disposed of according to law. So, I mean, of course, the native claims and the state selections were aimed at the same land, the best land. And since the Alaska Native title was based not only on occupancy but use, and Alaska Natives had used virtually all of Alaska except maybe glaciers and mountaintops, the two sections are talking about the same land. So there's a real conflict. First, right after statehood, the conflict was ignored, fortunately for the state of Alaska. And the state of Alaska was able to select certain land. It selected about, I think, 15% of its allotment before the land freeze was imposed. Part of what was selected were the very promising, geologically promising lands under which the North Slope oil lay. So That became approved, and effectively, the way the Department of Interior considered it, effectively the property of the state of Alaska. Before the Alaska Natives became aware that what was going on was something that had great potential to virtually preempt its rights under Section 4. But my co-panelist was one of the leaders who discovered that this process that was prejudicial to their interests was going on, and the Alaska Natives organized. They began protesting state selections, and they began filing their own claims to land. And in response to this action by the Secretary of the Interior, Stuart Udall, and I don't think when you look at the provisions of these two provisions, I don't think he had any choice. He issued a series of administrative orders saying that state selections would not be approved until native land claims were resolved. This was a big controversial thing among the local interests in Alaska, the non-native local interests in Alaska. But it was very much the context of the times. The super land freeze was in effect when the discovery was made. The second contextual thing of importance was the growing conservation movement. You know, when you think about the burning Cuyahoga River in Cleveland, and Rachel Carson's Silent Spring, smog in the Los Angeles basin. People were getting tired of these environmental disasters and became more and more environmentally conscious. So conservation groups were growing, the existing ones, new ones were being formed. And some of the conservation groups began to adopt litigation strategies in order to enforce environmental protections. And this was relatively new. Another new development on the conservation scene was the passage in 1969 of the National Environmental Policy Act. And this came after the discovery, but it played a major role in the pipeline litigation. So in this context, it's not at all surprising that lawsuits were filed. And the first lawsuit was filed by native villages against the pipeline, and Willie Hensley's going to discuss that. I'll discuss the consolidated cases in which I was involved. The Wilderness Society and also the Friends of the Earth and the Environmental Defense Fund filed suit to stop the pipeline. And their objective was to stop development on the North Slope. That was one objective. Another objective was to preserve wilderness. Another objective was to protect the caribou. And let's go to the next slide. And they had a vision concerning the caribou that I thought was interesting. I spoke to several of their representatives about it. And that was the North Slope was the place where the only remaining mass migrations of large mammals were taking place. That is, the buffalo were gone as a migratory species anyway. And the only place where you see this great wave of animals pouring out of the passes and into the plains was the North Slope, and they wanted to preserve it. Picture of it. I thought that was, I still remember them talking about it and having kind of a visionary way. I was in sympathy with it. They had other objectives, so if the pipeline was built, they wanted it to be built as safely as possible. And because transportation of oil by sea is a lot more environmentally dangerous than transportation of oil by pipeline, they wanted to have an all-land pipeline overland through Canada, discharging into the Midwestern United States. The point that the transportation of oil by sea is much more dangerous than transportation by pipeline was an area where the interests of the conservationists and the interests of the CDFU definitely coincided. We weren't interested in stopping development of the North Slope field, but it was clear to us that the tanker leg of the system was its weakness. More oil was spilled per unit of oil transported per mile by tanker than by pipeline by a lot. And that was really the formation. That was the basis for the CDFU opposition. But finally, we thought that if the combined system were built, at least we were there to point out salient risks of the maritime leg of the system. And having done that, we hope that effective mitigating measures could be recognized and adopted. Now I think we have another slide, slide 5. So they filed suit and got a preliminary injunction. And they got the injunction on 2 bases. One was the Mineral Leasing Act of 1920. It had a set of very distinct limitations and said in several different ways, no more. And the limitations were 25 feet on either side of the pipe, so 54 feet for the Alaska pipeline. Alyeska needed a lot more than that to build and maintain the pipeline. So it adopted the device of special land use permits that were allowed by regulations of the Department of the Interior, but only if they were revocable. The problem was the width beyond the allowable 54 feet was needed not just for construction, but it was needed for maintenance. In other words, the revocable permits would have to be in place for the whole life of the pipeline. Wilderness Society et al. Argued that this is just a sham. I don't know. I mean, it was, and that was one basis on which Judge Hart of the District Court for the District of Columbia granted a preliminary injunction. The other basis was this new creature, the National Environmental Policy Act, which required that an environmental impact statement detailing the environmental effects of any proposed major federal action be prepared. Nobody knew what that was. It had just, its effective date was January 1, 1970, so it was, it was like 2 months old, 3 months old. But it was clear that there was no environmental impact statement concerning the Trans-Alaska Pipeline. And so that too was the basis on which Judge Hart issued the preliminary injunction. So slide 6. Oh, this is my friend. You have to indulge me on this. This is Jim Mormon. He's the attorney who represented the conservation groups at the time of the preliminary injunction. protection. And he passed away recently, so I just thought I'd honor him with this mention. He did a great job, but we can go on to the next slide. In January of 1971, the Interior Department did issue an environmental impact statement of 196 pages. There was a lot of outrage in response to this impact statement. And, overwhelming testimony was presented concerning its inadequacy. In April of 1971, the CDFU filed suit, and we added a ground. We adopted the NEPA claims of the environmental groups, but we added arguments concerning specific navigational hazards in Prince William Sound and argued that they had to be recognized. And we added a challenge to the grant of land for the pipeline terminal in Valdez. The grant was of 802 acres. The Forest Service Organic Act only allowed leases of no greater than 80 acres and required them to be terminable after 30 years. So again, it was the same ruse that Interior had used, but Forest Service issued a revocable permit on which it was contemplated to build a tank farm and a ballast treatment plant, which are obviously permanent structures. So we argued that this was a sham that couldn't be permitted. And to stay with the chronology here, I need to observe that in December of 1971, the Alaska Native Claims Settlement Act was passed and signed by President Nixon. Earlier, Ed Patton, Alyeska's president, had come to realize the magnitude of the complexities and challenges presented by the Native claims. And so he made speeches to the Chambers of Commerce in Fairbanks and in Anchorage. And he was a man of few words. He said something like, no native claim settlement, no pipeline. Just get used to it. And this quickly had the effect of evaporating at least local opposition in Alaska to the native claims. In March of 1972, the final environmental impact statement was issued. It encompassed 9 volumes. It's about this high, and Alyeska's attorneys, government attorneys, were very fond of putting their hands up like this and saying, it's 14 inches tall, it weighs 10 pounds. It has to contain everything that the National Environmental Policy Act requires. The Secretary Morton, shortly after the impact statement, final one was published, indicated that he was about to grant permits, allow the pipeline to proceed, subject, of course, to Judge Hart's preliminary injunction, which was the only impediment at that point. And Judge Hart called us together and required us all to move for summary judgment, and we did so. All of us repeated the basic legal arguments that I've recounted today, but on behalf of the Cordova District Fisheries Union, we also made an argument that some salient risks to navigation had not been mentioned, despite the heft of the final EIS. And what we mentioned were that no mention had been made of the fact that several times each winter in Valdez Narrows, there were hurricane-force winds, extremely violent winds. And no mention had been made that sometimes icebergs, like what you see there, drift out of Columbia Bay, which debouches into lower Valdez Arm. And sometimes these icebergs drift out from Columbia Bay into the proposed tanker lanes. And no mention, no risk evaluation was made of this problem. NEPA requires, of course, that significant risks be discussed in the decision-making process, and beyond that, if the decision is to proceed with a project, why those risks are supposed to be discussed. Those risks are supposed to be thoughtfully considered, and minimizing or mitigating measures are supposed to be considered. They're supposed to be suggested. Sometimes they might even be imposed as a condition of granting a permit. But we never got to that stage because they didn't recognize that icebergs and hurricane force winds were a risk at all. And I was taken aback because you read the environmental impact statement, you can see, several pages devoted to the dangers to a certain wart on the in the Alaska range. And I've got nothing against warts, but I thought for sure, I mean, compared to hurricanes and icebergs, why you couldn't possibly say that the risks that we had presented were just negligible. But that actually was Alyeska's argument that you can't think of everything, and Judge Hart bought it, and go to the next risk, next slide, and issued a summary order on August 15, 1972, saying that summary judgment on behalf of the defendants was granted and denied on behalf of for the motions on behalf of the plaintiffs. We appealed to the DC Circuit. All parties asked for an en banc hearing and expedited proceedings. And that was granted. We had oral argument, and quite quickly the Circuit Court reversed on the grounds of the Mineral Leasing Act. That is, they said just about what I've recounted, why these strictures, 54-feet strictures, were quite clear. The legislative history was crystal clear. And the only way, the upshot was the only way the Alaska pipeline could be built was to get an amendment in Congress. And so that's where we were. The Circuit Court also rejected or declined to rule on our argument concerning the 802-acre pipeline terminal permit that had been issued as a revocable permit by the Forest Service, because the Attorney General of Alaska had written a letter saying that the state was in the process of selecting the land, and that would moot our contention under federal laws, which is correct enough. It hadn't happened, but the circuit just held that point in abeyance until and unless, and it eventually did happen. As to NEPA, the Circuit Court also didn't rule. It said that quite a bit, there might be quite a time process between now and when Congress amended the Mineral Leasing Act. In the interim, NEPA might, the Interior might change the final draft of the EIS. In fact, the Interior had been amending it in certain ways all along, so something further might be anticipated. And it said something that heartened me, which was that despite what Judge Hart said, there were genuine issues of material fact. And that heartened me because I thought, and that there would have to be either an evidentiary hearing or a trial. I thought that if there was, why we'd have a good chance of presenting some compelling evidence as to the risks involved in the high winds in the Narrows and the icebergs that come out of Columbia Bay into the channel just opposite Bly Reef. But alas, the Senator Jackson introduced a bill promptly after the Court of Appeals decision was published that would amend the Mineral Leasing Act in a way that would allow the pipeline to be built. I wasn't surprised by it. I mean, I thought that was necessarily going to happen. Another development that did happen, we can go to the next slide, was that there was a gas shortage. And it got worse as the spring turned to summer. And as the spring turned to summer, an amendment to the Jackson bill introduced by Senator Gravel, it was co-sponsored, I think, by Senator Stevens, was called the Gravel Amendment, though. And the Gravel Amendment said, the Department of the Interior and all other agencies have complied with the National Environmental Policy Act, and no further litigation concerning compliance with that act with respect to the Alaska pipeline is permitted. So if the Gravel Amendment passed, we would be required just to sit down and shut up. I wonder if my colleagues are thinking that's what I should do now. Anyway, I'll go on. I've got too much to say, I guess. But anyway, so the Gravel Amendment was introduced. And the gas lines, the lines at the gas stations got longer and longer. Go ahead and go to the next slide. You know, I mean, the shortage grew to sizable proportions indeed over the summer. But then go to the next slide. This great statesman now plays a role. The Gravel Amendment came up for a vote in the United States Senate on July 17th. And the vote in the Senate, 49 to 49. And Spiro Ted Agnew, Vice President of the United States, cast the deciding vote in favor of adopting the Gravel Amendment. That's the way it was. The House passed a similar amendment by a very close vote early August of '73, and we were basically over as far as the litigation of the Alaska pipeline case was concerned. The gas shortage was very suspicious to me. I mean, I don't regard myself as paranoid. And didn't then, but there was no good reason for it. There was no obvious reason for it. Let me put it that way, because there was no OPEC embargo or anything. What the what they were saying at the time was that, well, refiners had made a mistake as to the mix of products, and demand was unexpectedly high, and supply had been constrained by a price-fixing arrangement, or not price-fixing, price control measure that had been imposed by President Nixon because of inflationary concerns and so forth. Anyway, they're really all true. It was just a coincidence, because there are just too many actors to have it as a conspiracy. But it was our bad luck, and it was very consequential. So the necessary permits to build the pipeline were issued. The Hall Road was constructed in 1974. In March of 75, the pipeline itself was begun. It was completed in 77. In June of 1977, the first oil began to flow. Now, what are the objectives of the Wilderness Society plaintiffs? Well, they didn't prevent the development of the North Slope Hills. The Arctic coastal plain is not restricted from development. But given the undeveloped state of ANWR, the caribou still migrate in large numbers, and hopefully they'll always continue to do so. The delay between the initially proposed start of construction and when it actually started afforded time for Alyeska to modify its original design, which contemplated a buried pipe, and the time was well used. Instead of a buried pipeline, over 400 miles of the pipeline is on hurdle-like structures, and so the heat from the hot oil that's carried by the pipeline is far enough away from the ground and the permafrost, so that the permafrost in these elevated areas doesn't melt. And if it were otherwise, I'm sure that there would be serious problems and possibly ruptures. Also, it's really a good job of, as anyone who ever studied the pictures along the Denali Fault after the 2002 earthquake could attest, why it really is a good job of engineering. They put in these zigs and zags to prevent a rupture, and it really worked. So the delay inherent in the litigation process really facilitated a good design, and that's something that the environmentalists can take credit for. Even more important is the legislative result that they achieved. The conservation groups realized, as ANCSA was nearing passage, that a major allocation of Alaska public domain was underway. And so they lobbied Congress. They were able to insert into ANCSA 17D2. 17D2 provides that the Secretary of Interior will reserve, study, and report not more than 80 million acres of Alaska public domain for inclusion in 4 conservation systems, that is the national forests, national parks, national wildlife refuges, and wild and scenic river systems. The Secretary complied and made a recommendation encompassing just a little more than 80 million acres, 83 million acres, but Congress didn't act right away. Finally, in 1977, the House leadership acted, and they submitted their version of D2 compliance, which included 147 million acres for inclusion of the system. After a lot of back and forth, this was reduced to 104 million acres, and 104 million acres was encompassed in the act that actually fulfilled the promise of 17D2.
We're already an hour in.
What?
We're already an hour into the program.
Don't finish. Sure.
Okay, okay. I don't want to rush you.
Everybody's fascinated.
I know. Well, I am. I am very fascinated.
I can't go slower.
Okay.
I'm sorry. Anyhow, they got D2. We got 140 million, 104 million acres. You know how much 104 million acres is? California. It's huge. It's a remarkable victory. And that's why that's the main reason why their legacy is one of success. What happened to the CEFU? Go to the next slide. Our objective was to, this is an elephant, yeah. Okay, then go to the next one. So on March 23rd, when the Exxon Valdez discharged its pilot after passing through the Valdez Narrows, and then it picked up on its radar icebergs in the outbound tanker channel. So it proceeded and got permission to switch into the inbound tanker channel lane, and then it accelerated and continued eastward out of the inbound tanker lane until what must have been a moment of horror when the lookout reported that the Bly Reef light is 45 degrees to starboard. A tanker can't go starboard of Bly Reef. The Bly Reef light has to at all times be port. And so they didn't know where they were until then. And then corrective actions were taken, but too little, too late. And the Exxon Valdez was grounded on Bly Reef. So, you know the rest. There was a horrible oil spill. Go to the next slide. This is just detailing what happened. And then the next slide. The oil coated all of western Prince William Sound, and the southern Kenai Peninsula, and Cook Inlet, and parts of Afognak and Kodiak. This was just the sort of disaster that we had tried to prevent. When I learned of the spill, I thought it was a personal failure. I didn't think I did a bad job in the litigation, but I thought my failure came after the litigation was ended. I thought I should have engaged with the watchdog organizations to help them assert safety measures that could have prevented the Exxon Valdez disaster. Did such safety measures exist? Indeed, they certainly did, because they were imposed after the disaster. They included requiring marine pilots to stay on board until they were south of the area of great danger, south of Bly Reef, south of Columbia Bay. And only then could the marine pilots get off. 2 escort tugs are now required to accompany loaded tankers throughout their transit of Prince William Sound. There's a vessel monitoring system that keeps the vessels in sight and within voice command too, at all times within Prince William Sound. There's speed restrictions, weather parameters, and wind parameters have been established. There's periodic drug and alcohol testing. A tug is required to be tethered, actually physically attached to the stern of loaded tankers as they pass through the Narrows. And escort tugs are required to log and report the presence of icebergs along the route. And also, tankers must now be double-hulled. All these measures, except for double-hulled tankers, were practical measures that aren't, terribly expensive, and they could have been imposed if the effort had been made. So experience is a great teacher. Its lessons can be painful and expensive. The core idea of NEPA was to gain the knowledge needed to avoid disasters not by first experiencing them, but by careful thought about the risks of an undertaking, and thought too about how to eliminate or minimize the risks. So the pipeline was the first major test of NEPA. One could say that NEPA proved to be valuable insofar as it contributed to a better designed pipeline. But with respect to the marine transportation leg of the overall system, it was a dismal failure. I've got some thoughts on why it was a dismal failure, but if anyone's interested, maybe if there's a question and answer period, I'll address them then. My apologies. Thank you. Two and a half times too long. But the story takes a little telling.
Willie, you're next. Ready? I'd rather hear from you. You got some good stuff.
Is it close enough? Can you hear me okay? Okay. It's good to see some familiar faces out there. Walk around town these days, I don't see anybody I know. It's so old. Anyway, my name is Willie Hensley. I'm originally from Kotzebue. And named for my grandfather, the Raruk. Who was trying to pronounce it? Not bad. We have a G that's kind of a guttural G with a dot on it. It's a R, not a G. And in our language, Irrit is a mountain. Raruk is like a little mountain. We try to keep those names alive. We also have some other difficult sounds to. If we decide to change our name like Barrow did from Barrow to Utrecht, well, we'd have to change it to Kekektaruk. And that sound is not an easy one for people. It's like a K, but it's you close your throat and just kick some air out. And it actually has meaning. Kiktak is an island. Kekektaruk, that R-U-K on the end means a small island. So Kotzebue at one point in history was a small island, I guess. But the interesting thing is that just to show you the linguistic extent of the Inuit language, if you say Tiktak in the Kodiak area, they're Sukpiak, but it's an Inuit language. So if you say Tiktak or Tiktaktaruk, they'll understand it. All the way up in the Yupik country, in the Yukon-Kuskokwim, north of the Yukon, of course, Inupiaq country, all the way over to Mackenzie Delta, you say Tiktak, they'll know. You go over to Hudson's Bay, or on the edge of Hudson's Bay, all the way to Quebec and Labrador, you say Tiktak or Tiktak, Tiktaktaruk, they'll know what you're saying, and all the way to Greenland. So that's something that even I never quite understood a good part of my life, that the extent of the space that our culture covered from actually the North Pacific all the way to the North Atlantic. Anyway, we're here to talk about the pipeline, but of course it was inextricably linked with the question of who owned Alaska. And as someone who grew up in a different world, even than my own contemporaries, that is, our family were some of the last ones that actually lived in the sod homes that had been our mainstay for literally thousands of years up north. The missionaries who showed up at the turn of the century were intent on trying to change our way of life. By the way, these were Quakers from Richard Nixon's hometown, by the way, who came up in 1897 on a vessel called the Penelope. They were looking for gold. But in the end, they pretty much colonized Kotzebue, built a huge two-story school there, and eventually a hospital. They began to transform our lives, to convert us, to Christianity. they began to change our names because they couldn't pronounce them. And so they oftentimes named our families after themselves, like the Newlands and like the Hensleys, right? I never knew who Hensley was until recently, actually. We found a document where there was a William F. Hensley who had registered a marriage, so he was a missionary. I have no idea where he came from. But when they ran out of their own names, they started using famous Americans. In fact, I was delivered by the wife of Abraham Lincoln, and Blanche Lincoln. And I knew Robert E. Lee and George Washington. When they ran out of those names, they started calling blacks, browns, whites, those families that carry those names now. Anyway, in any case, we've had to sort of experience a great deal of change. In those days, there were no schools, of course, in high schools in rural Alaska in the 60s. I was raised in the 40s and 50s. Spent one winter in Norvik up the river. And in those days, the BIA decided if you went to high school or not and where, or if. In fact, I remember Evan Hobson's story. He was in the Senate, early Senate. And he also was the first mayor of the North Slope Borough, but he wanted to go to high school and apparently showed up to get on the North Star, which is a government ship that used to come up in the summers to deliver goods for everybody, the stores and everybody else. He showed up with his little suitcase hoping to go to high school, but they said there was no room at the high school. So he never got a formal education. I ended up in boarding school in Tennessee for 4 years. Couldn't afford to come back home during the summers, except once. As it turns out, it was the day that the statehood bill passed, the Senate. And I happened to be in Fairbanks. And they were marching to and fro in the parade. They were celebrating, honking their horns, and a big star in a balloon with a 49 on it. And I think somebody was trying to turn the Chena Ridge into gold, but it turned green, I think. But in any case, what I didn't know, of course, was that that bill essentially was an authorization by the new state to steal about 103 million acres of our land without our consent and without so much as a hearing. In any case, at that point, of course, I didn't know that. I was just finishing my second year in high school. So this whole issue, I mean, we never even remotely thought in our wildest dreams that this land would never be ours. We had occupied it literally for thousands of years. Talk about my part of Alaska, and I think this feeling was similar across the state. And so I never really, unlike you, who somehow knew exactly why you wanted to be a lawyer or a doctor or this or that, I never had any career guidance. I just knew that I was supposed to go to school. It was no real goal in mind. And so I actually went all the way through, high school in Tennessee, Fairbanks a couple of years, then George Washington University, where I finally got my degree. I literally had no idea why I was doing all this, right? But as it turns out, I learned how to write some. I learned how to do a little bit of research. I liked the study of economics. I switched to political science at GW at a time, when there was a lot of ferment in the country, with the poverty program, the war, the civil rights issue. You just couldn't help but absorb all that. But of course, my degree was really the most useless degree in America, but I made a living with it, and it served me just quite well, as it turns out, as in terms of what I eventually got involved with. But when I was lonesome for Alaska, I used to go to the Library of Congress to just read the Alaska news. Right, they were 2 or 3 months old, But I began to notice some concerns that were being expressed by villagers along the rail belt here, because statehood had arrived in '59, and that 103 million acres really was designed to provide the basis for Alaska's wealth and survival as a state, right? And so as the state started making those selections, you know, those Indian villages say, hey, wait a minute, this is our land. But of course, they had no paperwork. They didn't have nothing to confirm that. So I decided to study that. When I finished at George Washington, I went to Fairbanks, and Jay Rabinowitz was living there. He's the youngest member of the court, Supreme Court, and my assessment was that he was probably bored stiff because this is 7 years after statehood. I mean, how many cases could there possibly be up there? You know, so I decided to teach a course in constitutional law, and I had no legal training whatsoever. So there were just about 8 or 9 of us in this class. That was the most important thing I did up to that point in my education, because he said to write a paper on any subject of a legal nature. And so this gave me a chance to really kind of look at this issue of really who owned Alaska. And so I think Mike Bradner was in the course, Kirk Wickersham was in the course, 2 people that some of you might know. And so I decided to go back and look at the Indian treaty era to, you know, try to understand that. Those were contracts, right? They're recognized in the Constitution. It's the law of the land. And then I took a look at the Treaty of Cession. I was trying to think, what did the Russians think they had to sell, and what was the heck was the Americans thinking they were buying, and what did it say about us, right? And I couldn't understand how 800 Russians, the most that were maybe ever in Alaska at any one time, how could they choose to own and control and have authority over a continent-sized area in which they hadn't seen most of the places, and there were 40, 50,000 of us already here? What kind of law is that, right? Of course, I didn't understand at that point the basis of some of this thinking that goes back to the 1500s and the Pope and the kings and the queens, etc. And so then I looked at the Organic Acts, you know, and when I saw the provision where the Congress essentially promised protection for our use and occupancy of our lands or any land claimed by us. And when I saw that, I said, hey, we claim it all. This is ours. This is ours. And so in reality, the underlying Aboriginal title had never been extinguished through all the legislation, the treaties, the Organic Acts, the Emissions Act of 1900, the Indian Citizenship Act of 1924 that allowed us to vote finally, the Indian Reorganization Act of 1934 and applied to Alaska in 1936, that the basis of our tribes up here, all the way to the Statehood Act. I looked at the Statehood Act, and even there, as you saw, the state was disclaiming all right or title to any of our lands either. But of course, you know what? Nobody ever defined what our lands were. And so the interpretation by the new state was that they had carte blanche to go anywhere they wanted to select lands anywhere, okay? So my great aha as a budding lawyer, even though I wasn't in law school, when I realized that when the state decided to make a selection, say of a 100,000 acre tract somewhere in Alaska, it went through the BLM process. Once it got to the secretary, when he signed that, that was an extinguishment. And if we ever had a chance to get the land back, we'd never get it. We'd be shunted off to the Court of Claims, and which is completely stacked against the Native people. So when in my little study, I read that the Tlingit Haida had spent 35 years in court in litigation in the Court of Claims and ended up with a measly $7.5 million for, 18 million acres of Tongass forest and not 1 square inch of land. What the heck? That's highway robbery. That's not even halfway fair. And so even as a 24-year-old at the time, I knew that if we were ever going to pursue anything, it had to be something new, because the reservation system, in my opinion, was never going to fly in Alaska. So I see it, there are 2 main conditions. If the state was not a participant in the resolution of the issue, nothing was going to pass Congress. So the state had to be engaged, and they had to be pushing forward on something. And then on the other side, on the Native side, if we were in disarray, that was a deal killer. So we had to work very, very hard on trying to keep our troops together. And there were lots of issues in there that eventually on both sides ended up shaping the ultimate settlement, okay? And so when I finished my little paper, while I was in the process of finishing it, I saw in the newspaper something that Ernest Greening said. Anybody knew Greening? Ernest Greening, yeah, well, some old timers, really old timers. Anyway, Ernest Greening was about my age, actually, maybe a little younger. He said something in the newspaper that really struck me. I was still finishing my little paper. And he said something like, well, what we need to do is pay off the natives and get on with the development of this land. When I saw that, I got a little pissed. Well, let's put it this way, a little angry, because I thought he was throwing cold water, on what rights we might have, and also the assumption was that we couldn't develop anything. Of course, it was easy to believe that back in those days because we had nothing really. We had no organizations, we had no capital. We were living hand to mouth out in the country on fishing, hunting, and trapping. Anyway, so I decided to write him a letter, which I think I have a copy of here somewhere, basically challenging his perspective. And I decided to call him on it. I was living on campus, in Fairbanks. So I decided, well, it's a public issue. I'm going to send a copy to the Thunder Times, to Bob Atwood right here in this building, biggest paper in town in the state. And I sent it to the Newsmine in Fairbanks and the Anchorage Daily News. And everybody printed it, except Bob Atwood. Of course, I didn't know his history at that point. But in any case, a few weeks later, anybody know Claire Fayes, the artist? Yes. People of the No Attack, great, wonderful artist from New York. She was Jewish. She was a friend of Greening's. So he must have called her when he saw that. This is in 66, spring of 66. And so she calls me at the dorm. Somebody says, hey, Hensley, you got a phone call? It's down the hall, the dorm. And so it's Claire. She says, well, Willie, the senator saw your article and your letter to the editors, and he wants to talk to you. I said, oh, cripes. I knew he's calling me to the tool shed, right? Anyway, so I said, oh, yeah, sure, I'll talk to him. Well, so we met at the old Nordale Hotel, and it's just the two of us. And I just remember distinctly, he was sitting on the bed, and his feet were dangling. He was short. And I was sitting in the chair, and he said three things. He said, well, Willie, he said, I'm the governor who that passed the Civil Rights Bill in the 40s, that got rid of the no dogs or natives allowed signs, or no natives allowed, or no natives need to apply, And he said, I'm also the governor who encouraged your people to run for office. And then he said, on the land issue, he said, I've been trying to get the secretary to do something about this issue, and he's done nothing. And so, of course, at that point, we had no organization, no AFN or anything, and we were just on our own, And so I said, well, I said, Senator, I said, you did the right thing on the civil rights thing, get rid of those nasty signs and stuff. And I said, on the political side, yeah, that was great because our people need to run for office because they're affected by the laws. I said, but on that issue, on the issue of the land, I said, you were a proponent of statehood that authorized the taking of our land without compensation. And I said, besides, the secretary can't solve the problem. It's a congressional responsibility. And so we went our separate ways. But I did not know his history and why he was. I sensed immediately, and I was just following my instincts, like I had to do from then on this major issue of both the land settlement and the pipeline, was that he was not going to be a friend. And what I discovered later was that when he was territorial governor, Secretary Ickes, head of the Interior Department under FDR, had authority under the Indian Reorganization Act to establish reservations by executive order of different sizes, whatever. And when Ickes allowed the creation of the Venati Reservation of 1.5 million acres up north for 15, or was it 29 families? Anyway, not a huge number. I mean, I think he was incensed, and so was Bob Atwood. So you had this left-wing Greening, great supporter, I mean, great man, really, in many respects. You know, Harvard guy, diplomat, senator, governor, writer, blah, 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 medical doctor. And then conservative Bob Atwood, they saw the same when it came to native land ownership, or post. So thank goodness, a couple of years later, we managed to get Gravel elected. At that point, I didn't know the significance of that reality, but had he been re-elected, we would have had a very, very tough time, and because of this. Okay, I don't want to take as much time as he did, but let me see if I can finish my story. The issue of land claims had never been studied for 100 years until Senator Jackson authorized Bill Van Ness, who he had just hired, this young attorney, to work for him. Jackson had just taken over the Interior Committee from Clinton Anderson from New Mexico. And Jackson was a lawyer, like you guys, and he had lots of tribes in his state. And he also was around for the statehood fight. So he understood the issue of Indian land issue problems. In fact, I think he may have been the author of the Indian Claims Commission Act, which was designed to speed up that slow court of claims process. Because there's a bunch of claims, you know, throughout the country. So he asked Bill Van Ness he said, look, we may have a problem in Alaska. And if we're going to pass something, we have to have a big study. So he made a contract, Van Ness did. By the way, it wasn't the executive doing this, it was the Senate, interestingly enough. And so who did they hire? Joe Fitzgerald. Anybody know Joe Fitzgerald? Yeah, a couple, yeah. He was sent here to help Anchorage recover from the earthquake. And the Federal Field Committee was a bunch of federal agencies designed to sort of focus on helping Anchorage. So there was not a single native on his staff, but they got that contract. And my friends, Bob Arnold, Esther Wanicki, you know, David Hickok, Doug Jones, the economist, they put their minds to work. There's not a shred of indigenous perspective on this subject. But they came up with that 10-pounder, talk about the EPA. This is a 10-pounder Federal Field Committee report. And the only thing that I could see that was of any value in that, I mean, they were pretty good on land description, land use. That was good. But they came up with that $1 billion figure. That was the biggest figure. And the only thing that I could see in there that was any real significant value. But their idea that we had to fight, they saw village life as an inhibition to civilization, so to speak. They were going to use the settlement as a vehicle to really eliminate cultures and turn us into ordinary Americans, which is always a goal of a colonist, a colonial power, right? Become one people. And so the way they're going to do it was, in their recommendation, whatever land and money came under the settlement was going to go to a presidential appointed board, not majority native, of course. They were going to issue stock to everybody, and in 10 years, it was going to go public. So that was going to be the end of it. There was going to be no village corporations, no regional corporations, nothing really indigenous. So we had to beat that down, okay, which we eventually did. And so getting to the story of the pipeline, we had a hero in Secretary Udall. He was the most hated man by the non-native people because he was stopping their hopes and dreams of becoming rich, you know, and successful as a state. But you know, he was the trustee for native lands, you know, reservations, allotments, you name it. But in Alaska, he wasn't sure. I mean, and I think he finally realized that if he allowed the state selections, that was going to be an extinguishment, and that was not, he was not going to do that. So he initially issued the land freeze, which was sort of like a letter, really. But eventually, when Nixon was elected, he did the super freeze order, which just literally stopped everything. And so he, we owe, on our side, we owe him a lot. I think we all do, because I think he helped us all to get a relatively equitable resolution. And, but even then, his suggestion was only about 10 million acres and about 180 million bucks, based on the highest per capita amount that I think the Senecas got on a settlement over the Kinsua Dam. And so we had to raise our favorite friend, his recommendations way up high, And so what we did was working with Wally Hickel, who we had fought tooth and tongue over that land freeze. And he was going to run over us. He was a go-getter. And, so we actually worked an arrangement with him because AFN had no money. We couldn't even bring people to town to hammer out a position. We had no communication system, just the post office. And so we agreed with Wally to form a task force under the Rural Affairs Commission, which he had created so that he could spend state money to get us to town. And so we essentially put the entire AFN board on it, and they selected the drafting committee, which I chaired. And our job was to come up with ideas that would help get the state moving forward, because without the state, as I said, there was no movement on a bill. And so they needed some glimmer of hope and a way forward. And if we had come out and said we wanted 200 reservations, that was a deal killer, right? The state would never go for that. But when we came up with the idea of private property, which wouldn't be run by the BIA, and a state chartered corporation, now that was something the state could get excited about. So we recommended that, those two ideas, plus the idea of revenue sharing. In our by the way, Barry Jackson, Cliff Crow were heavily engaged in that. And this was as close to a tripartite arrangement as we came to, because in all the meetings of our task force, it came down to about 7 of us: Johnny Sackett, myself, Joey Dixon, Nadi, John Burbridge, a couple of others. There was always an undersecretary of the Interior, Robert Vaughn, sitting there. And there was also Attorney General of Alaska, or Ed Boyko. Anybody remember Ed? Roar of the Snow Tiger? He was a kind of a strange guy, but on this issue, he was good. I think he helped Wally move forward on this. In fact, Wally, before he became secretary, was the first to support the 40 million acres as an elected official, which is a big deal for us because of the work of this task force. So I think that the results of that work, in my opinion, began to change the public perception of this problem, and they could see a way forward. And you could see it in the newspapers, and even the state even passed a piece of legislation committing $50 million to the cause. But of course, it was contingent on lifting the land freeze, which we couldn't abide. But still, it was an indication of things moving forward. So the long and the short of it was, our great hero was gone. Nixon was elected. Wally Hickel, our great enemy, was about to be our nemesis, because we knew damn well he was going to go down there, and his job was to get rid of that land freeze and build that damn pipeline and forget about it. Well, we knew they were going to forget about it. So we fought to keep that land freeze. And the way we did it, and our ground was shifting away from under us as the AFN. And in this fashion, Jack Anderson discovered that Wally Hickel, when he was governor, had pressured the Yupik Eskimos out in Bethel to sell their king salmon to American processors as opposed to the Japanese, who offered them more money. And he sent the troopers out there to scare the hell out of them. And that got in a national column by Jack Anderson, and he said he wasn't fit to be secretary. Well, so the Democrats saw an opportunity maybe to nail one of the appointees of Nixon. And so they scrutinized him like mightily. And so Alaskans were so worried that they flew a truth squad to Washington, a plane load of supporters of all walks of life. Then some of our own board members were on that plane. You know, they were caving in. They were willing to take a chance on that freeze being lifted without a settlement on the land claims. And the rest of us were not. So they sent Emil Nutty, myself, John Borbridge, and Evan Hobson to DC to see if we could rescue this freeze. We could not get a commitment from Wally naturally. So we had no choice but to go to Senator Jackson and the committee, and we pled with them to not approve his nomination without a commitment on the freeze. And by gosh, Jackson did it. And I'll never forget that moment when Wally realized that his job was contingent on his response, yes or no. When he responded, no, he would not do anything with the freeze without consulting the committee. But we knew we had won that point. Robert Zelnick wrote about that for the Daily News. I have that article somewhere. But so what it did was it actually, he was essentially crossing the line, right, between the executive and the legislature, in a sense, because Wally had every right to deal with it as an executive. But so it put the onus on a committee, on a Congress really to do something. And that's how we got that. Now, I'll shut up right now, but now getting back to the pipeline. I was president of AFN. I get a call. Bill Van Ness, Senator Jackson would like to talk to you. So I got Sam Kito anyway, you know Sam. Quarter Clinton, 3/4 Japanese from Petersburg. And so I took him with me, and we walked to Van Ness's office. I pushed the door open, and I said, "Hey, Bill, who called this meeting?" From behind the door. And I said, "Oh, I did. It was just Senator Jackson, which was about to come out." And so I was a little naive. I think he was not so crude as to say, "Well, Willie, you know, I got you $1 billion and 44 million acres of land. Now I need you." So I said, "Senator," I said, "thank you for all you've done." I said, "I've got a couple of problems." And what I wanted to ensure was that we, from the villages out there, had a chance to get some of that jobs and training during the construction of the pipeline and thereafter. Also, I was concerned about compensation in the event of a spill along the villages. I didn't want to have to go through long litigation and stuff to get compensation for, say, damage to their water supplies or the community. And so what he did, he sends me down to the Interior Department, and I secured Section 29 into the grant of right-of-way, which assured an opportunity for us to go to work with us. We knew we were going to get inundated by expert pipeliners from Texas and Oklahoma and God knows where. And so with that, what was being said by the opposition to the pipeline was that Alaskans were opposed to the pipeline for a whole variety of reasons, including subsistence. And that was why Jackson called us. And so I was pretending like I was uncertain. I had one letter opposed, one letter enforced, but I needed the commitment. In fact, I was interested in numbers too, in terms of numbers of jobs. So we got a commitment on a number of jobs and an enforcement mechanism. I almost pushed too far. Bill Van Ness almost walked away, and I said, "Wait," and I turned around, I signed this letter, handed it over to Bill, and he gave it to the senator who put it into the congressional record. So when that vote was tied, 49-49, would it have made a difference if we had said no? I don't know, but it would have been cutting our own throat because $500 million was at stake because 2% of that, the 2% overriding royalty was going to pay for, $500 million of the settlement, without oil production, so I was caught in a box there, but we did the best we could. And that's how, that was our experience with the pipeline. Anyway, so we had the Alaska Native Utilization Agreement that the Alaska Pipeline has lived with ever since, well, they actually forgot about it for 15 years. Really, we all did actually, but they were under threat of litigation for lost wages and they kind of regenerated. And oddly enough, Bob Malone hired me to help put it back together in Alaska before I went off to represent them in Washington DC for about 10 years. But it's been quite an experience. I mean, the pipeline, it has, of course, it's turned Alaska into what we have. I mean, I don't think we would not have 700,000 people here if it hadn't been for oil. All the great things that it's been able to do for our communities. But I worry about the future. I'm sure you do. It's grim. Alaska is a hard place to live. It's not cheap. There's very, very few things that make economic sense. You know, we can't run the state on timber. We can't run the state on tourism. You know, we can't run the state on fish. You know, so what have we got? We're going to go back to hunting and fishing and tracking. Thank you.
We're going to just keep going. I know we're going to go over time a little bit, but I welcome everyone to continue to stay with us. And then for the next two speakers, please take your allotted time.
Well, so like all good lawyers, I'll start by saying I'll be brief. I'll just try to cut this down to a few quick observations. I came to Juneau in 1971 and I was stars in my eyes. I was the last of all the new lawyers to show up. And by the time I got to Juneau, all these other boy wonders, I suppose you'd say, had gotten themselves attached to the greatest projects you could imagine, working to implement the new Department of Environmental Conservation, trying to set up or helping to set up the state-operated school system, working with the governor to try to figure out whether the state could own the pipeline, build and own it, et cetera, et cetera. And I got the first assignment, which was to review the reindeer slaughterhouse regulations, which had been, I found when I opened the file, had been kicked around through 8 different lawyers over 5 years. But I just did my job. And I had a couple other pretty lame assignments. And then one day, Judge John Havelock called me into his office and he said, you know, things are going to hell out in Washington, D.C. And the governor's decided that the state should intervene in this case, this Trans-Alaska Pipeline royalty or right-of-way case. And I was amazed to learn that this case had been going on for almost 2 years. The oil companies and the state of Alaska were just now talking about intervening. Actually, before this happened, the Department of Interior had moved to, this was like the Hail Mary pass after they'd lost these injunctions. They had moved to change venue to Anchorage. And I'm not sure what the consequence of that would have been. That's a nice alternative future we could imagine. But they actually got Pete LeBate, who somebody here might remember, who was the president of the Bar Association at the time, to provide an affidavit for the Washington, D.C. judge explaining that Anchorage was full of excellent lawyers, extremely competent on these very complex federal law issues. And all these lawyers in Anchorage would love to take on this litigation pro bono against the oil industry. Well, that was apparently not persuasive to the judge. So the case stayed in DC. And the only thing I want to mention about, I got assigned to work on the case for the state, and I got the strange experience of being sent back to Washington, D.C. to work with the state's law firm, Covington and Burling, and fumble around, you know, in my fashion as a cub lawyer trying to help out on this case. But I learned a lot. Wow. And one of the things that I learned, and it really sinks in retrospect, was really how naive these companies and the state were at this time. How silly. The state had received $900 billion in the bonus lease sale, the bonus bids on the 1969 lease sale. The companies had announced that they were going to start building a pipeline in 1971. And they'd already, as Justice Matthews pointed out, they'd already ordered 800 miles of pipe from Japan. Everyone was swinging from the chandeliers because Governor Hickel had gone to Washington to run the Department of Interior. What could be wrong with any of this? This was like time for a party. And so the party started, and the state started spending money like crazy. That $900 million went pretty darn fast. But for some reason, people still seem to be optimistic. I don't know what they were thinking when, like a week before Governor Hickel showed up to take over at the Department of Interior, Stuart Udall issued the super freeze, so-called. The land is completely shut down, frozen. What were they thinking when Congress is deliberating on proposals that ultimately became NEPA and passed NEPA?
I had a little too much.
Nixon signed NEPA, and we know from the judge's injunctions a year earlier that the Mineral Leasing Act evidently doesn't even allow any of this. So the party continues in Juneau. And everyone evidently is in total denial about what's actually going to happen here. The state spent that money down so fast, as some of you will remember, assuming that the pipeline was actually going to start producing dollars in 1974, that the state had to go borrow money from the oil companies, in effect, to keep the state government running for several years. They did that through the reserves tax. Interesting, questionable device whereby the state, basically it's an ad valorem tax on oil and gas in the ground, which results in a credit that the producers will take if and when they get to produce it. That will go dollar for dollar, plus interest, I'm sure, on their production tax obligations. But so, first observation, I'm just fascinated when I look at this in retrospect to see how incredibly naive the state and the oil industry was in the face of these seemingly insuperable obstacles. The other point I wanted to make about the pipeline litigation is that I think generally the public overlooks the matter of who actually stopped the music on this thing. And there's the Wilderness Society, there was Friends of the Earth, so forth. There were all the politicians and all the academic people. But there was also Alaska Legal Services Corporation, assisted by some lawyers in Washington, D.C., who filed a lawsuit. They beat the environmentalists to the punch. They filed a lawsuit in that same district court in Washington, D.C., several weeks before the environmentalists got to it. And they got the injunction. That was the injunction. It was 5 villages along the right-of-way. Willie, you can help me on this. Ramparts, Battles, Minto, Stevens Village, and Allakaket. Stevens Village was the one that was an IRA, and that it was the one that actually had about 20 miles of road that was going to be built on the land it claimed. The judge shut it down. So let's not forget, with these thousands of lawyers crawling all over this project, from all over the country, that the original shutdown, the original injunction that set all this, what we're hearing about today, in motion, was obtained by Stevens Village.
David Wolf. Legal services.
Yes, and legal services, David Wolf. I called David the other day to interview him. Couldn't track him. So I had a great time working on the DC Court of Appeals briefing. As a cub lawyer with all these lawyers in Washington, DC, and I kept thinking, in the back of my mind, these people are all going out to the Hay Adams for lunch for $500, you know? And they've got like high-paid people bringing them tea and crumpets at the office and billing gigantic fees. This is all going into the tariff, you know? Who's going to pay for this? We're going to pay for this. So I think that the litigation itself was great learning experience for the state. The scales fell from their eyes, so to speak. And what happened was that there was this, I mean, this is my retrospective view of it. There was this great shock of recognition in Juneau, well, throughout the state, but focusing in Juneau, Willie was there. Wait a minute, what are we doing here? We don't have a pipeline. We don't have a pipeline permit. We're burning up our $900 million. And furthermore, we've realized now that the oil companies who own these leases are multinational, vertically integrated companies that own their pipeline companies, they own their tankers, they own their refineries. Actually, way back at the beginning, when the Alaska Department of Natural Resources had to develop an oil and gas lease, this was years earlier, they needed a good, competent oil and gas lease that would pass in the trade and work for the people of the state. So the commissioner at the time went into his network of colleagues and eventually found a lawyer who would draft this oil and gas lease for the state. The lawyer was provided by the Western Oil and Gas Association, and the oil industry paid for it. He was actually at Pillsbury, Madison, and Sutro down in LA, and he was a very prominent, superb oil and gas lawyer who worked for the oil industry. So we got a wonderful oil and gas lease drafted by the industry. And that, unbeknownst probably to most of the people in the state government, which is an interesting little footnote to all of this, because you know there's that thing about how in the case of an ambiguity, a legal document is to be interpreted against the draftsman. Who is that? I think that this actually was litigated in a case that Justice Matthews may have participated in. So, but anyway, so the states got to figure out what to do, because the state has recognized now that because of this procedure, because of the vertically integrated companies, and because of the fact that there's no transaction occurring at the point of production or at pump station one, how are we going to figure out what this oil is worth for purposes of royalties, taxes, and various other royalty production taxes and various other tax mechanisms? And so the answer to that is you got to go downstream as far as you have to go to find a market transaction, determine the true value, not the fake value, of the transaction at that downstream point. And then you've got to figure out how much it costs to get it there and subtract all of that, the so-called net back method, right? So the state, as I said, is growing up really fast about the facts of life here. As as things are stalled back in Washington DC. And the state is saying, we'd better get control over this situation or we're not going to get any money out of this. So my favorite episode in this, favorite in part because I got to be involved in it and I spent most of a year working on it with a little team that was Wilson Condon, whom some of you may know, a friend of his from law school who came up to help out, the guy who Will found by calling his old professor at Stanford Law School, a kid basically, who was looking for a job. Tom Williams came up, and then I got to be involved in the team. And we worked together on the litigation about the state right-of-way leasing act. Now, this was the law under which the state would grant the right-of-way that would go with the federal right-of-way to allow construction of the pipeline over all these several hundred miles of state land. Now, the origin of this was that in the legislature, which was essentially a bunch of lawyers, I think there were like 12 or 15 lawyers in the legislature and Willie.
Pretend lawyer.
Right. Chancey Croft was deeply involved in this. I think he might have been president of the Senate at some point. I'm not sure. But anyway, Chancey called a law professor of his down in Texas, Joe Witherspoon, and said, what are we going to do about this? The oil companies are going to eat our lunch. We have no idea what's going on with all these pricing issues, and we'll never be able to figure out what a barrel of oil is worth when it gets to a refinery somewhere. We don't know anything about tariffs. And what we know is that they're vertically integrated companies, so this is just transfer pricing. Doesn't matter to them. They're going to get all the money, and there's not going to be any money left when we determine what's the value of that barrel up at the top. So Chancey calls his old law professor, Joe Witherspoon. Joe Witherspoon comes up with this magnificent idea. Well, why don't we just have a percentage rental on the lease? Instead of charging what we were charging for leases like this or permits, fair market value for the land, you know, what the vast market in Anchorage, Alaska, or in Bettles or wherever would pay for this. Instead of that, let's have a percentage lease that says, you pay us what it's worth to you, and we'll have it on a sliding scale. And so if, as the state expected, the oil companies would be able to have their way with the ICC or the FERC, which regulated their tariffs, and they could just charge whatever they wanted to carry the oil and then subtract that, so the value at the top end would be de minimis. If they're going to do that, well, we'll just get the money back through this percentage lease mechanism instead. Essentially, a trump card on what the state anticipated that the oil industry was going to be doing when they initiated, when they turned the tap on and started shipping. Well, actually, the state was right to be worried about that. If you go look at in 1977, the oil industry, or the producers, I should say, needed a tariff before they turned on the tap and started shipping the oil. They filed their federal tariffs. By the way, it's 7 pipes, it's not 1. 7 or 8 pipes. They're individual pipeline companies owning shares, and each one of them has its own separate tariff. They filed their tariffs, as is typical with regulatory agencies, the interim tariff, which is essentially the carrier's proposal, and then the ICC has the authority to suspend the tariff if it doesn't like it, or just let them go ahead and charge the tariff, and then eventually in the tariff proceeding as it grinds out, we'll figure out whether that's the right number or not. In this case, they filed interim tariffs, each of the 7, I think, pipeline companies. BP had essentially half of it. They were immediately challenged in the circuit court, I think the 5th Circuit maybe. And then that went to the US Supreme Court. And if you look at the US Supreme Court opinion in 1978, it's fascinating. Footnote, whatever it is, footnote 12, maybe 14, is a table that shows the tariffs that they filed and the tariffs that the ICC was willing to let them have. And you can see the difference in the tariffs between what they tried and what the ICC gave them, which was even at that quite disputable. The difference between that, considering the volume of oil that was going to be coming through that pipeline, was maybe $4 or $5 billion that would have come out of the state's share. So essentially, it showed that Joe Witherspoon, the professor who Chancey hired, was right. This was a serious problem, needing serious attention. So off we go. And this is the part I got to be involved in that was so much fun for a young lawyer. The legislature passes the Right-of-Way Leasing Act, 1972. The oil industry sued immediately in Anchorage. And it's all about this percentage lease concept. They said, wait a minute, you guys. This is a violation of the Dormant Commerce Clause. You're screwing around with the federal government's ability to regulate interstate commerce. This is preempted even by the ICC laws. It's a taking. It's, what else could they say? Well, it's a breach of contract. We have these oil and gas leases that say we're entitled to produce and remove the oil. You can't do this. Impairment of contracts and so forth. And furthermore, by the way, fellas, we've got this permit that's kind of like a lease from the Department of Natural Resources, from the director of the Division of Lands. It's like 1 page long. And this was back 3 years earlier when everybody was so excited. Remember, it was like it's a big party and we're all aligned and this is great. So they got that. They said, we've already got our right of way. Well, there's something about you need statutory authority to grant a right of way like this. And under the state constitution, you're supposed to have prior public notice and all that kind of stuff. So all this stuff is swirling around. Meanwhile, people are scrambling back in Washington, D.C., as you've heard, trying to get the big federal issues resolved. And this case went on, this case about Joe Witherspoon's idea about how to make sure the state gets its fair share went on for a year or more. During that time, essentially, Will Condon and Tom Williams learned how the whole system works. I mean, to the best of their ability. This was like going to school, big time for them. The average, I think the average years of experience of the lawyers working on this team was maybe under 2 years since law school. And they're against like 100 or 150 lawyers from all the major law firms, the lower 48, who are bombing us daily with motions and stuff. Well, ultimately what happened is that Governor Egan was persuaded the following year, maybe Willie was part of this, I'm not sure, to enter into a grand settlement of all these economic issues. This was more or less contemporaneous with the passage of the Trans-Alaska Pipeline Authorization Act. This is like everything's coming to the grand conclusion. So there was a special session in Juneau, the fall 1973. And Joe Witherspoon's wonderful right-of-way leasing act went down in flames. It was replaced with a very charitable version, somewhat like what was imagined to exist before. And some important tax laws were passed. And basically the regime under which the state would receive its share of the money was established in this special session. And as a part of that, the oil industry, or the producers, I should say, and their pipeline companies received the right-of-way from the state that they required. I've got lots of other wonderful things to say, but I think I think I'll just yield it to my friend, Professor White. Thank you.
All right, I'm going to scrap my original presentation. And I'm just going to say a few comments about what my esteemed colleagues have said here. And we do have some nice slides here. Can we go to the next slide? I was going to talk about the marine regulation of the system and a bunch of the lawsuits that were pertaining to that, both what is the design of the tankers originally, some of the state lawsuits around trying to design those, Chevron v. Hammond, Arco v. Ray in Washington State, and then how the oil pollution OPA 90 came about after the Exxon Valdez. But instead, maybe I'll just take a step back and think about this from the highest level, right? The Trans-Alaska Pipeline System is the most expensive private industrial project in world history, okay? If you were to build the project again today, it would cost over $100 billion, okay? The reason why is you have to add up the cost of the pipeline, which was $8 billion in 1977, 10 times the original estimate. You also have to add the oil field costs, right? And then you have to add the tankers onto that as well, right? This is vertical integration, just what Jim Reeves was talking about. And so when you add all of those up, you get to something pretty close to $20 billion in 1977. Which is over $100 billion today. The reason that I say this is because as the lead Alyeska engineer was talking about, this is Frank Mullen, he was the lead engineer. During pipeline construction, he said, you can't even get 100 people in a room to begin to understand how big this project is. So as we sit here trying to wrap our arms around this, I am not surprised Justice Matthews took as long as he did, or Willie Hensley provided the depth, because that is what this requires, right? You've really got to go down the rabbit hole to understand all these things, and we don't have the time today, so we're not going to go down all the rabbit holes, but maybe I'll just say a few things. So Justice Matthews, I really appreciate that you brought up Columbia Glacier, because that was a major factor in the Exxon Valdez spill, right? Turning outside of the tanker lanes. And, you know, the Exxon Valdez was an environmental disaster, but it was also a disaster emanating from a harsh environment. And we really have to think about the tankers. You know, one of my main arguments is, okay, we all think about the Trans-Alaska Pipeline System as a pipeline from Prudhoe Bay to Valdez. It's not. Next slide. What it really is this terra aqueous carbon conduit, right? The whole point wasn't get the oil to Valdez, right? The 3,000 people of Valdez or whatever don't need 2 million barrels a day of oil. The whole point was to get it to downstream markets, the most voracious consumers in world history. And so if we follow the oil, if we understand the system the way that its corporate owners did, we as Alaskans can best protect our interests, right? Whether those are maritime, whether those are fiscal. And too often in our history, we have not understood this system properly. And therefore, we have failed to regulate it properly. Whether that comes to tanker regulations, whether that comes to tariffs. You know, you hear the word tariffs, and okay, let's put aside everything that's happened politically right now. Usually people's eyes glaze over. This is the most important part of pipeline regulation. You have to understand tariffs. So I was very happy when Jim brought that up. And let me just say one very shocking figure, and Robin Brenna actually gave this to me, which is, so the state basically failed to properly regulate our tariffs on the pipeline. And shameless plug, if you want to understand more about this, check out the most recent Alaska Law Review, where my colleague Catherine Roche and I have an article about this, and I summarize the history of tariff disputes. And if we had properly regulated those tariffs between 1977 and, right about 2000, right, we lost something like $10 billion from that. If we would have properly regulated those, the permanent fund would be twice the size today. Okay? And every year that goes by is more money that is missed out because we did not invest it. Okay? $80 billion today. What is it going to be 10 years from now, 20 years from now? So pipeline regulation is extremely important, even if you think it's boring. The other thing I'd say about NEPA coming about, big picture, this infrastructure was so big, taking place in, what environmentalists called the last chance to do it right the first time, right? Alaska, the last great wilderness. At a moment in time that Wally Hickel called an environmental revolution, right? Secretary of the Interior said that. So if you think about the high-level policy changes that were required to bring about this pipeline, they have been absolutely transformational for modern Alaska. It's not just ANCSA and ANILCA, but there's ample evidence that the passage of NEPA itself was passed in order to deal with issues like the Alaska pipeline, right? I have seen Scoop Jackson's letters talking about this. And by the way, this comes about right after Santa Barbara. So you have this big oil spill and people are saying, let's prevent this again. Senator Jackson's getting all these letters from environmentalists who are worried about oil spills and they're worried about Alaska. And Jackson's like, this is why we're going to pass NEPA, so that this doesn't happen again. I think that's really important context to understand. The other fascinating thing is you've heard from multiple individuals here about Judge Hart in DC and his injunctions. One of the fascinating things is he actually understood Alaska because he had worked on the Defense Early Warning Line in northern Alaska in the 1950s. He had worked on the DEW line. So he had some appreciation for Alaskan issues, perhaps issues like permafrost in Alaska. And so I should also, let me give a plug here to my colleague. There we go. Yeah, really stole it here. So for those who want to learn more about the history, I cannot recommend this highly enough. Lisa Weissler's book, Capital Crude, The Impact of Oil on Alaska Politics. So obviously this is a huge subject and she doesn't just talk about the pipeline, but she's got this wonderful story of the lease, right? The lease that Prudhoe Bay is on today, the DL1 lease that Jim Reeves was just talking about, that was written by a lawyer for the Western Oil and Gas Association, right? She's got that wonderful story in this book. And if you think about it, if you think about the entire political project of Alaska statehood, right? You go back to our constitutional framers who 70 years ago were sitting in a room at the University of Alaska. Their whole project was about preventing what they called the Kennecott syndrome, which was ensuring that outside corporations couldn't come in, extract our wealth, and not leave a share of those resources, a fair share perhaps, for the long-term population of Alaska. And so if you think about that project in the context of the pipeline, that's really important because we have often not retained a fair share of our resources in Alaska. It's really important to think about things like tariffs and leases. So big picture, I'm writing a book about this, so I can be up here all day. I'll just leave it there. I think we've had a number of fantastic insights, and I don't know if we have any, we obviously don't have much time left because we're over time, but if there's questions, I'm happy to talk to folks afterwards as well. All right, thank you.
Well, I'll just say thank you all for sticking with us, and those are online, thank you as well. Thank you for our panelists. We truly do appreciate it. Have a great day. Bye.